I'd like to commence this evening's event by acknowledging that I work on the land of the people of the Kulin Nation, and to pay my respects to their elders past, present, and to their emerging elders also. Good evening and a very warm welcome to you. I'm Pip Nicholson, Dean of the Melbourne Law School, and it is a particular pleasure to welcome you tonight. Can I deal with a few housekeeping matters before we proceed to the program for this evening? The first is that the chat function has been disabled, but we do indeed welcome your questions and ask that you put them through the Q&A function. So a quick reminder that the chat function's disabled, but questions are very warmly encouraged and welcomed through the Q&A function. You should also note that this evening's proceedings are being recorded and will soon be available on our website. Let me turn to say a little bit about the background of this evening's proceedings and then a little bit about how we're going to move through them. First of all, the Law School would very much like to thank the Alan Missen Foundation for their generous support of this evening. The Alan Missen Foundation was established in 1988 to commemorate the memory of the late Senator Alan Missen, indeed an alumnus of this law school, graduating in 1946 with an LLB and coming back to us to take out a master's in 1947. Alan Missen was for many years very active in public life, including being a foundation member of the Liberal Party of Australia. And he is also very well known as an exceptionally strong advocate for civil liberties and human rights. The aim of the foundation is to promote public education concerning civil liberties and human rights. And the foundation achieves that through support or sponsorship to events and organisations that promote education in and concerning both civil rights and civil liberties and human rights. We are indeed very grateful to the foundation and very much enjoyed our cooperation across 2021. I will shortly hand over to Tony Pagone, who will give a few remarks on behalf of the Alan Missen Foundation. His remarks will be followed by an introduction to our fabulous panel, comprising, as you're probably aware, Tim Goodwin from the Victorian Bar, Professors Jason Varuhas, Michelle Foster, Adrian Stone, and Professor Emeritus Cheryl Saunders. I would like to thank Jason Varuhas, co-director of the Centre for Comparative Constitutional Studies, for not only introducing the panel this evening, but being instrumental in the design of tonight's discussion of the High Court of Australia and civil liberties. I think Tony and I both very much enjoyed working with Jason as he designed the discussion that will follow tonight. Tony Pagone will be well known to many of you, a very eminent jurist and indeed a leader of jurists across the world. He's currently joining us from Italy. Tony, a very warm welcome to you.
Thank you, Pip, and I think I've got the technology now working. I am grateful to be able to be present. I wasn't going to mention that I was not with you all in lockdown, and I hope that my relative position won't be taken amiss. It's great to be with you. It's also an enormous pleasure for me as a member of the board of the trustees of the Alan Missen Foundation to welcome you all this evening for the 2021 oration as part of the activities and lectures of the law school. The foundation is delighted to support the university and indeed the advancement of knowledge and education about civil liberties as much as you can. Some of you who are here may never have heard of Alan Missen, and it's a great pity because his stance in supporting the values was a role model for all of us today and those who are currently in political office. Alan Missen was the embodiment of a principled politician and a defender of civil liberties and human rights. He was born in 1925. He graduated, as Pip said, from the University of Melbourne, and then became a barrister and solicitor. He was indeed a founding member of the Liberal Party in 1944 and was elected to the Senate as a Liberal Party senator for Victoria in 1974, and he was re-elected 5 times. Missen was not afraid to speak out on issues of civil liberties and human rights, even when his views conflicted with the policies of his party. He frequently took stances on principles that were in conflict with those of other members. In the early 1950s, Missen incurred the wrath of the then Prime Minister, Mr. Menzies, when he, Missen, a member of the Liberal Party, actively opposed and campaigned against the passing of the Communist Party Dissolution Act, which was subsequently declared unconstitutional by the High Court, and also by his active campaigning against the referendum to change the Constitution to give to Parliament the power that was needed to enact such a provision. He published a powerful critique of the referendum proposal in August 1951 that, in terms that still resonate all these years later, he said, "Remember that this is, in essence, a totalitarian power to be given for all time. Ask yourself why the Constitution and the High Court, which has for 50 years provided the best defence against the tyranny of elected persons, should not continue to do so." Missen's philosophy included as core components a belief in a welfare system which provided properly for the poor and for those in need, a recognition of the particular needs of the young, of Indigenous people, of sick and disabled. He had a commitment to achieving equality of opportunity, of restoring accountability of the executive and its agencies to Parliament and the people. He had long-sighted attention to the living conditions of Australia, conservation of our heritage, the preservation of the environment. During his time in the Senate, Alan Missen crossed the floor 37 times. He was, throughout his political career, a proud wearer of what has come to be known as the small L Liberal monarchy. He frequently challenged those in power and is the very model of the kind of person who I think many civil libertarians would want to support. 2 years after his death, the foundation was established by a group of people associated with what was then called the Victorian Council for Civil Liberties, and now known as Liberty Victoria, for the purposes that Pip has indicated. We are delighted to be able to sponsor this oration. We're delighted by the way it has been organised. We thank Pip in particular, the principal speakers, and Jason, to whom I now give the floor. Thank you.
Thank you, Tony, very much for those remarks and recollections of Senator Missen. Good evening, everyone. I'm Jason Varuhas, a Professor of Law at Melbourne Law School and Co-Director of the Law School Centre for Comparative Constitutional Studies. Let me first echo the Dean's welcome. We've had a fantastic response to this event, and it's a pleasure to welcome all of those present, including those in Melbourne, from across Australia, and those tuning in from abroad. Let me also, on behalf of the Centre for Comparative Constitutional Studies, express my gratitude to the Alan Missen Foundation for its support of this event. The event is in large part inspired by the late Senator Missen's strong interest in civil liberties and his commitment to principled and robust debate of such matters in the public sphere. I'll introduce our panel of speakers in a moment, but let me first make 3 very brief points by way of introduction to this event. So first, there are currently many civil liberties issues being debated in this country. Our focus tonight is upon a number of the most significant High Court of Australia judgments in the field of civil liberties delivered over the last 2 years or so, and specifically on judgments relating to immigration detention, law enforcement, and Indigenous rights. The judgments to be discussed are significant in their own right, but they also provide a lens through which to examine how the current High Court conceptualizes its role in relation to the protection of civil liberties, and a basis for critical reflection on what the High Court's role ought to be in protecting civil liberties. Second, the concept of civil liberties, like all legal concepts, is one that is often used, but less often defined. In its classical sense, it refers to the idea that individuals are free to do anything that the law does not prohibit. As such, liberty is that residue of freedom that is left when one accounts for all of the constraints imposed on the individual by law. In this event, we'll adopt a slightly more inclusive definition and take civil liberties to denote very basic or fundamental interests. These interests would include basic aspects of well-being, such as physical integrity or liberty. And our particular concern this evening is with the legal protection of such interests, typically against government. The third preliminary point concerns the multi-streamed nature of legal protection of basic interests in Australia. When one thinks of the protection of civil liberties, one might naturally think of rights charters, such as the Victorian Charter on Human Rights. Such charters are important, but they are also only one aspect of the law's protection of basic human interests, and notably, there is no federal Bill of Rights. As the presentations today will bring home, there is a range of legal mechanisms for protecting basic interests, including common law protections, such as tort and the law of native title, statutory protections, and constitutional protections, and one may also add administrative law. Thus, the protection of basic interests is not the exclusive province of any one field of law. So it gives me great pleasure now to introduce our distinguished panel. Professor Michelle Foster is a professor of law at Melbourne Law School and the inaugural director of the Peter McMullen Centre on Statelessness. Mr. Tim Goodwin is a barrister at the Victorian Bar and a member of List A Barristers. Professor Cheryl Saunders AO is Laureate Professor Emeritus at Melbourne Law School, convener of the law school's Constitutional Transformation Network, and the Foundation Director of the Centre for Comparative Constitutional Studies. And lastly, there's me, and I've already introduced myself. Now, in terms of the running order, Professor Foster will first address immigration detention. I will then speak to cases on law enforcement. Tim Goodwin will then address recent High Court decisions affecting Indigenous rights, and Professor Saunders will then offer some more general reflections on the role of the High Court. Each speaker will speak for approximately 15 minutes, and after the panelists have spoken, there will then be 15 to 20 minutes for questions at the end, with the question and answer session chaired by Professor Adrian Stone, who is a co-director of the Centre for Comparative Constitutional Studies. So I'll now pass over to our first speaker, Professor Foster, who will address the topic of immigration detention.
Well, thank you, Jason, for that generous introduction and for convening this important event tonight. Now, there is no freestanding right to liberty in the Australian Constitution, yet the protection of liberty has often been cited as one of the purposes of Chapter 3 of the Constitution, that is, the separation of judicial from legislative and executive power. Indeed, as Justice Gageler noted in 2015, concern for the protection of personal liberty lies at the core of our inherited constitutional tradition, which includes the inheritance of the common law. Liberty is the most elementary and important of those basic common law rights. His Honour went on to cite Sir William Blackstone from the 18th century, who explained, to quote, "The confinement of the person by secretly hurrying him to jail where his sufferings are unknown or forgotten is a less public, a less striking, and therefore a more dangerous engine of arbitrary government." In my talk today, I'll focus on the High Court's jurisprudence concerning the scheme of mandatory indefinite immigration detention, a scheme that has come before the court many times since its inception in the early 1990s, but most recently was upheld by a narrow 4-3 majority in AGL 20. To provide some context, there are currently 1,440 persons in Australian onshore immigration detention facilities. The average time in detention is currently 696 days, but 8% of those currently in detention have been held for more than 1,825 days. That is more than 5 years. I mention this to emphasise that this is not a hypothetical or purely academic issue. Rather, with international human rights bodies having found, one, that our scheme constitutes arbitrary deprivation of liberty, and two, that in some cases, the suffering of those in Australian detention has amounted to cruel, inhuman or degrading treatment, Blackstone's concerns resonate in this contemporary context. But first, some background. When mandatory immigration detention was introduced in the early 1990s, its constitutionality was immediately challenged in the High Court in the case of Lim. Now, in adjudicating the applicant's claim that the legislative provisions which authorised their executive detention improperly conferred judicial power on the executive, the court in Lim elucidated a view of Chapter 3 that suggested significant potential as a source of liberty. In the key judgment, Justices Brennan, Dean and Dawson explained that the most important exclusively judicial function is the adjudgment and punishment of criminal guilt under a law of the Commonwealth. From this followed the principle that, subject to limited exceptions, the citizens of this country enjoy, at least in times of peace, a constitutional immunity from being imprisoned by Commonwealth authority, except pursuant to an order by a court in the exercise of the judicial power of the Commonwealth. Now, if you were listening carefully, you would have noticed the word citizens, and of course that term was pivotal. The converse principle was that the status, rights and immunities enjoyed by an alien, that is a non-citizen, are substantially different from those enjoyed by a citizen. Most relevantly, the alien is vulnerable to exclusion or deportation. And so the court held that the Commonwealth Parliament's power to legislate with respect to aliens, as provided in section 5119 of the Constitution, encompasses the conferral upon the executive of authority to detain an alien in custody for the purposes of expulsion or deportation, and that such power constitutes an incident of executive power. However, the court was very careful to emphasise that the legislature's ability to confer this executive power was limited to what is reasonably capable of being seen as necessary for the purposes of deportation, or to enable an application for an entry permit, what we would now consider a visa, to be made and assessed. If the detention were so limited, or if the detention authorised were not so limited, it would be of a punitive nature and contravene the separation of powers principle. Now, in concluding that the provisions in Lim were appropriately limited, the court placed weight on the fact that the legislation prescribed a maximum total period of 273 days in detention, as well as the fact that a detainee could request removal from Australia. So this suggested that both the purpose of the detention, but also the means of the detention were relevant to assessing validity. But of course, Lim was almost 30 years ago. So what has changed since then? Well, as will be well known to many of you in the audience, a decade later, the court revisited the central reasoning in Lim in the case of Al-Kateb, which considered the ongoing detention of a stateless Palestinian man who'd been found not to be a refugee and couldn't be released from detention, therefore, on a protection visa. But Mr. Al-Kateb faced potentially permanent indefinite detention because by then the Migration Act had been amended so that detention was no longer time limited, and Mr. Al-Kateb's statelessness meant that he couldn't bring his detention to an end by requesting to be removed because no country is required to admit a stateless person. His challenge was rejected, though, by a narrow 4-3 majority. And I think the crucial step in Al-Kateb was to move away from the insistence in Lim that executive detention be limited to what is reasonably capable of being seen as necessary for the purposes of deportation or visa processing. Instead, the court adopted a more deferential test which focused squarely on the purpose of detention. And since, in that case, the detention's purpose was said by the court to ensure that non-citizens do not enter Australia or the Australian community and can be deported when and if it's practicable to do so, it was non-punitive and hence did not infringe Chapter 3 of the Constitution. However, in a series of more recent cases concerning challenges to various aspects of the Commonwealth's immigration detention policy, the court has emphasised that the Migration Act, quote, does not authorise detention at the unconstrained discretion of the executive. In these cases, the court appeared to embrace the reasoning of Lim anew, emphasising that the power of the executive to detain is limited by, one, the purpose of the detention, and two, that it exists only so long as is reasonably necessary to effect that purpose. And some members of the court had further clarified the reasoning in Lim. For example, Justices Crennan, Bell and Gageler explained in M76 that the necessity referred to in the Lim test imports a temporal element such that the period of detention must be limited to the time necessarily taken in the relevant administrative processes, which are directed to the limited purposes for which detention can be effected. And really crucially, they emphasised that what begins as lawful custody under a valid statutory provision can cease to be so. So that catches you up a little bit. This brings us to AGL 20. Now, many thought that although previous challenges had not succeeded on constitutional grounds, the signs were there that the High Court was starting to move away from Al-Kateb. However, in AGL 20 decided in June this year, in the words of Justice Edelman in dissent, the court took the decision of Al-Kateb one large step further. So what was the case about? Well, AGL 20 is a Syrian citizen who arrived in Australia in May 2005 on a child visa. 9 years later, in 2014, the minister cancelled his visa on character grounds, meaning he was then an unlawful non-citizen, and accordingly was required to be detained under Section 1891 of the Migration Act. Now, AGL 20 made a number of applications for a protection visa, but they were refused, not because he didn't need protection. He's from Syria. He has a well-founded fear of being persecuted and could not be returned to Syria. But the protection visas were refused on character grounds. Now, on the 25th of July 2019, the minister refused to consider granting him, say, a bridging visa or an alternative visa under Section 195A of the Act. Accordingly, from the following day, so the day after the minister decided not to grant him an alternative visa, he could have been released from detention by being removed to Syria. The minister accepted that he was at risk, that AGL 20 was at risk of refoulement, so return to persecution, and hence it would contravene Australia's international obligations to return him to Syria. But Section 197C of the Act provided that Australia's international non-refoulement obligations were irrelevant to a decision to deport. So what does all that mean? Well, to put it simply, AGL 20 could have been removed, but the minister, that is, returned to, so removed from detention by being sent back to Syria. But the minister took into account a factor that, while it was very morally important, was not legally relevant, at least in terms of domestic law, in deciding not to remove him. Indeed, it was expressly conceded by the Commonwealth that AGL 20 had not been removed from Australia as soon as was reasonably practicable, which is what the Act requires. So in the federal court, Justice Bromberg found that because of this failure, the detention had ceased to be lawful. So what starts as lawful detention can cease to be so, as the court had previously said. And Justice Bromberg found that this was the case from the 26th of July 2019, and thus granted a writ of habeas corpus. But in the High Court, a majority of 4 judges, and that comprised Chief Justice Kiefel and Justices Gageler, Keane and Stewart, set aside Justice Bromberg's orders on the basis that the conclusion that officers of the executive had not discharged their duty to remove AGL 20 as soon as was reasonably practicable affords a basis for an order of mandamus, that is, an order to require him to be removed. But an order that he be released would be to, quote, subvert the scheme set out in the Migration Act. So what was the basis of the majority decision? How did they reach that point? Well, importantly, the majority did cite and apparently adopt the Lim test. So it wasn't a rejection of the Lim test, but they appeared to apply it in what I would say is a very deferential manner, whereby validity turns only on the connection between the detention and the segregation or removal. And the court spent a lot of time talking about purpose. Their honours characterised the primary judge as having made a leap, to quote, from a finding of a failure by the executive to remove the respondent as soon as reasonably practicable as required by the Act, to the conclusion that the executive was detaining the respondent for a purpose other than his removal from Australia. So the majority said that was too big a leap. But we might ask, is this really a leap? The Commonwealth admitted to have taken no steps to remove him, even though it was reasonably practicable to do so, which plainly calls into question whether he was being held for the purpose of removal. However, even more worryingly, the majority described as problematic the notion that pursuit by the executive of a purpose that is unauthorised or even prohibited by the Act might render the detention invalid. But we might ask why this is so. In previous authority, it had been made clear that detention could only remain lawful where it was carried out to effect the purpose of assessing a visa, deciding whether to assess a visa or effecting removal as soon as reasonably practicable. The majority continued as follows, to quote, provided the requisite knowledge or suspicion that a person is an unlawful non-citizen continues to exist throughout the period of detention, an unauthorised or prohibited purpose on the part of the officer in prolonging the period of detention can affect neither the duty to detain, nor the duty to remove, nor the appropriate remedy for non-performance of the duty to remove. So just to recap, the majority found that an unauthorised or prohibited purpose was irrelevant to the legality of detention. This appears to reduce the criterion of validity of detention to a single test, namely whether the detainee is an unlawful non-citizen. It seems difficult to disagree with Justices Gordon and Gleeson in dissent, who argue that, to quote, the logical and inevitable consequence of the Commonwealth's submission is that, perhaps absent express malice, detention could lawfully continue for so long as the executive chose, notwithstanding non-compliance with the Act. Their Honours continued. Put differently, the Commonwealth's contention would enable detention of unlawful non-citizens at the unconstrained discretion of the executive. The terminating event, that is, to return as soon as reasonably practicable, may never occur, despite it being reasonably practicable, yet detention would remain lawful. In their view, that would render the Chapter 3 limits on executive detention meaningless. Justice Edelman, also in dissent, observed that the express and implied boundaries of the Migration Act would be exploded if the executive could act for purposes that are objectively inconsistent with the scope and purposes of the Act. Justice Edelman strongly disagreed with what he regarded as the consequence of the majority's view, namely that the Migration Act would be an island of freedom from established legal concepts, permitting the executive to act for any purpose in the exercise of its powers or the performance of its duties, no matter how far that purpose departs from the express or implied terms of statutory authority. So what are the implications of AGL 20? Well, in the remaining few minutes that I have, I will raise three questions that you may like to ponder and we may like to come back to later. First question relates to the role of the court in assessing the validity of detention by reference to the LIM test. In other words, what does the LIM test mean in light of AGL 20? Well, as I've already said, the majority appears to have minimised the role of purpose, finding that the Act can authorise detention for a purpose other than assessing a visa or removing a non-citizen. And as to whether it's limited to what is reasonably capable of being seen as necessary, well, it's difficult to see any role for this aspect of the test, so long as the detainee is an unlawful non-citizen. The second question relates to the role of habeas corpus as a remedy. Now in LIM, going back 30 years, the joint judgment explained that under the common law of Australia and subject to qualification in the case of an enemy alien in time of war, an alien who is within this country, whether lawfully or unlawfully, is not an outlaw. As such, if he or she is unlawfully detained by an officer of the Commonwealth, the writ of habeas corpus is an available remedy. But in AGL 20, the majority stated that, to quote, because the evident intention of the Act is that an unlawful non-citizen may not in any circumstances be at liberty in the Australian community, no question of release on habeas can arise. Is it really the case that the intention of Parliament confines the remedies that the High Court may provide? Justices Gordon and Gleeson vehemently disagreed, describing this conclusion as an abdication by the court of performance of its obligations, which would bring the law into disrepute. In any event, in their view, singularity of remedy has never been the way of the common law. All of these questions raise the role of the High Court because in each of them, the majority has taken a very deferential, non-interventionist approach. The majority is concerned about the relationship between the Parliament and the executive being subverted. But we could ask the same question about whether this decision subverts the role of the court vis-a-vis the other branches of government. And my third and final question is how our jurisprudence has strayed so far from that of our British inheritance. It's interesting to observe that British judges have had no such reservations in intervening to control immigration detention. Now, some of you may be thinking, oh, but that's because they have the Human Rights Act and the European Convention on Human Rights. And this is true, they provide very robust protection. But even pre-Human Rights Act, the courts took a very active role in supervising immigration detention. Indeed, in 1983, the House of Lords held that the fact that we're considering detention which is incidental to expulsion from the country strengthens rather than weakens the case for a robust exercise of the judicial function in safeguarding rights. And in that same year, the Queen's Bench Division established what have come to be known as the Hardy-Singh principles, namely that the power to detain is subject to limitations that the court read into the relevant legislation. And these are, first, it can authorise detention only if the individual is being detained pending the making of a deportation order and pending his removal. It cannot be used for any other purpose. Secondly, while there was no time limit in the legislation, the power of detention is impliedly limited to a period which is reasonably necessary for that purpose. And third, if it is apparent to the Secretary of State that he or she is not going to be able to remove persons who are intended to be deported within a reasonable time, it would be wrong for the Secretary of State to seek to exercise his power of detention. In Australia, there is an alternative to detention, as Justice Edelman in dissent emphasised, namely release on a bridging or temporary visa. However, on current authority, it is not clear what the fate will be of AGL 20, who is, according to media reports, only 29 years of age. Thank you. I'll now hand over to Jason for his presentation.
So, hello again. So the focus of my talk today is a trilogy of recent High Court decisions: Smethurst, Lewis, and Roy. I'm considering these cases together because they all involve tort claims against public officials in the police and prison contexts. More specifically, they all involve claims based in trespassory torts, such as trespass to land and false imprisonment, which have long afforded strong protection to very basic rights in person and property. Importantly, these actions have long played a fundamental role, specifically in protecting individuals in the face of unlawful government action. Courts have regularly imposed significant damages awards on public defenders who invade individual rights absent lawful authority. As such, these actions have been an important vehicle for vindicating the rule of law principle of government under law. But a further reason for considering these cases together is that they reveal certain concerning trends in the reasoning of the High Court, or at least a majority of the court. In particular, these cases raise concerns over judicial methodology, transparency in judicial reasoning, and consistency with fundamental principle. Moreover, each decision peels back the protection of basic individual rights in ways that empower government. So my principal focus will be concerns over the mode of reasoning adopted in these decisions. So let me briefly introduce that concern before examining the cases. So when a court makes a decision about whether and how the law should develop, it does not make that decision on the basis simply of what it thinks is the best legal norm or the best outcome. Legal reasoning is a constrained or disciplined form of reasoning. Legal decisions must be made against the background of the pre-existing body of rules and principles and the deeper normative commitments embedded within the law. So the question for a court is not what is the best rule or best outcome, but rather what is the best rule or outcome as against the pre-existing framework of legal principle. Put simply, a legal development will generally be an extrapolation from what exists and must be capable of rationalization in the light of what has gone before. A central problem with each of the cases under consideration is that that was not the approach taken by a majority of the court. So let me now discuss this concern in relation to each of these cases. So turning first to Smethurst. In Smethurst, the police conducted a search of Annika Smethurst's premises and possessions, but they did so on the basis of a flawed warrant. As such, the police committed a trespass to land and to goods. One key question before the High Court was whether, in response to this trespass, Smethurst could get an injunction ordering the police to return the data the police had obtained through their unlawful search. Specifically, she sought an injunction under Section 75(5) of the Constitution. By a majority, the High Court denied the injunction. So let's focus in on one issue. Assuming there was an in-principle case for grant of the injunction, should the court deny the injunction within its remedial discretion? Now, in thinking about how a court ought to approach this remedial question, one would think that the starting point would be to consider two matters. First, what are the normative concerns that inform the constitutional jurisdiction to grant an injunction against Commonwealth officers? Second, what normative concerns underpin the law of trespass? Logically, it's the normative commitments that underpin the constitutional jurisdiction and the law of trespass that ought to frame how decisions over the constitutional injunction should be made in a case of official trespass. Now, in regard to the constitutional injunction, the High Court has in past jurisprudence held that a core concern in forming remedies under Section 75(5) is the rule of law, which includes the concept of government under law. In regard to trespass, the core underlying concern is strong protection of the right to exclusive possession of land, a right sacred in the common law tradition. As such, if a court were minded to deny a constitutional injunction where a person has suffered a trespass through unlawful police action, one might think that the court must at least confront or address these normative concerns. If property rights are fundamental and a rights interference raises rule of law concerns, it's a large thing to deny relief. But while the minority judges reasoned from those starting points, the plurality judgment is devoid of any consideration of fundamental principle. Thus, when the plurality considered how to exercise its remedial discretion, the importance of property rights or the rule of law don't get a mention. The only consideration discussed, and which was therefore determinative, was a concern to facilitate a possible police prosecution, and for that reason, the injunction should be denied so that police could retain the data. And this was despite there being no evidence before the court that a prosecution was contemplated, and indeed no prosecution ever materialized. So it's difficult not to view this analysis as unmoored from the law's normative commitments, not least as those commitments were not ever interrogated. So let's move on then to the second case of Lewis. So Lewis was on periodic detention, but he failed to attend. So the sentencing board decided to call him into jail. But the board's decision was procedurally unfair and thus invalid. It followed that Lewis's detention in jail for 82 days was unlawful and constituted false imprisonment. The issue before the High Court was what damages Lewis was entitled to. The court held that he should only receive nominal damages of $1. The court reasoned on a counterfactual basis that but for the board's procedurally flawed process, the board would have adopted a lawful process and detained Lewis anyway. Because Lewis's detention was inevitable, he suffered no loss and should receive no substantial damages. Now, if one is confronted with a question as to the approach to damages and false imprisonment, the starting point of analysis should, one would think, be the pre-existing rules and principles relating to false imprisonment and the normative concerns that underpin that action. In terms of precedent, false imprisonment has existed for centuries. Its origins are ancient. But before the very recent line of decisions, such as Lewis, denying damages to plaintiffs altogether, there is no case of false imprisonment that can be found where substantial damages were denied completely on a but-for analysis. Across the 16th, 17th, 18th, 19th, and 20th centuries, there is no such decision. What this indicates is that the law of false imprisonment never knew a causal principle such as that was asserted in Lewis. Rather, substantial damages were always given for false imprisonment. And that makes sense if one considers the deeper concerns that underpin false imprisonment. Like trespass, the tort is constituted to afford strong protection to very basic rights, namely liberty, and awarding substantial damages wherever the right is unlawfully invaded serves to strongly uphold that right. Put another way, a strongly vindicatory approach to damages serves to effectuate the law's normative commitments. Now, in contrast to what I've just outlined, the High Court in Lewis did not start with an account of centuries of damages jurisprudence in false imprisonment, nor the law's long-standing commitment to liberty. Rather, the analytical starting point was an acontextual general principle of causation, which was asserted, and damages were denied based on that principle. Now, if the principle in Lewis is not explicable by reference to precedent, nor the normative concerns that underpin false imprisonment, the question must arise, what is the legal basis for adopting the principle? And the answer is far from clear. So let us move on then to our third case in the torts trilogy, Roy. So this case involved police entry onto land. The police entered private property to check if the plaintiff was complying with a domestic violence order as part of a practice known as proactive policing. The police required her to take a breath test, and that showed that she'd been consuming alcohol in the company of her partner. That was a breach of the domestic violence order, and she was therefore charged and prosecuted. Now, there was no statutory basis on these facts for the police to enter the land. So on the face of it, this was a trespass. However, a majority of the High Court supplied a common law basis for entry by recognizing an implied license for the police to enter the land. So Roy is a trespass case. And as noted, trespass is a tort concerned to afford strong protection to exclusive possession. An implied license is a presumptive limit on that right, and paradigm examples of tacit licenses that have been recognized at common law include a license to walk up to someone's door, to talk to them, or to deliver a parcel. But Roy concerned the quite different situation where police entered the property with one of their purposes being to possibly exercise coercive powers against a guest of the occupier. Now, in deciding whether to recognize a license to support such entry, the logical starting point is the right to exclusive possession of land, the very essence of which is that it affords an occupier absolute power to decide who may enter their property. It's, after all, that right which trespass serves to protect. And indeed, that was the starting point of the minority in the case who refused to recognize a license. The majority starting point, however, was altogether different. They reasoned from emphatic statements that domestic violence is a scourge on society and that it's important to facilitate the practice of proactive policing. Now, I don't know whether proactive policing is something to be encouraged because I haven't conducted a study of proactive policing, and the court didn't have one before it either. But we would all share the judge's conviction that domestic violence is an evil to be vanquished. But whether that policy concern should ground a license is an issue that does not arise in the ether. It arises in a specific doctrinal context and must be viewed through the normative lens of the law. And within that framework, the starting point is maintenance of exclusive possession. Another salient feature of the legal framework is that Parliament has accounted for the policy against domestic violence, providing a comprehensive scheme of police powers to counter domestic abuse. And yet, Parliament did not confer a power of entry to cover circumstances such as Roy. Now, these points were not seriously confronted by the majority because their judgments do not start from the law's normative starting points and reason outwards from those starting points. Rather, the judge's reasoning proceeds from public policies that they consider to be worthwhile. So to summarize, if one is engaged in orthodox legal reasoning one must reason towards new rules and outcomes in the light of the background legal framework, including the law's pre-existing normative commitments. One is not working from a tabula rasa. Rather, one is seeking to place a small tile in a pre-existing mosaic, and the tile has to fit within and be intelligible as against all of the other tiles in the mosaic. There are real questions whether the majorities in the cases considered approach their task in this way. Now, this issue is exacerbated by the fact that the majorities in these cases do not confront the normative choices being made in a transparent way. For example, it would be one thing to say in Smethurst or Roy, we recognize the right to exclusive possession is fundamental, but we think it should be caveated. And here are the reasons why public policy outweighs the law's commitment to fundamental rights. But that is not what was done. Instead, one finds an assertion such as proactive policing is good, or the police need this data, and the outcome follows from that assertion. Similarly, in Lewis, it would be one thing for the court to say, there is scant authority for the principle we propose, and it undermines protection of liberty, but we think this change in the law is justified for the following reasons. But instead, what we have is the assertion of a causal meta-principle as if it were a self-evident truth. So there is a failure in these cases to transparently confront and reason by reference to the law's pre-existing framework of principle and long-standing normative commitments. So far, the point I've been making is one concerning method, but I want to also make a point about where these decisions take us. It's not just that the decisions do not take the law's normative commitments seriously, but they invert the law's normative priorities. The law's starting point in trespass has traditionally been the strong protection of property rights. But in Smethurst and Roy, High Court majorities proceeded instead from an explicit premise that police action should be facilitated. In false imprisonment, the law's traditional starting point is a presumption in favor of liberty. But in Lewis, the court, in applying its counterfactual analysis, adopted an irrebuttable presumption that the board, the defendant, would have otherwise exercised their powers lawfully. As the Irish Court of Appeal has observed subsequently, this turns the tort on its head. A starting point of preservation of liberty is supplanted by an assumption of legality in favor of government. One might think that such inversions of principle in long-standing legal fields are for Parliament, not the courts. Now, this brings us lastly to the separation of powers. We all know the High Court is committed to a strict conception of the separation of powers. It follows that the court has a narrow conception of the judicial role. Aspects of this include a commitment to incrementalism with any significant leap forward for Parliament, and the court eschews appeal to public policy because policy is for the political branches. We see this approach manifested in various contexts, including negligence and vicarious liability. And yet, in Roy, for example, we find a majority directly appealing to the policy of proactive policing as a premise for granting police greater power to enter property. This is a departure from the traditional approach to implied licenses, which according to which licenses are implied from the factual circumstances of the case, with the law developing on the basis of factual analogies to previous cases. So we see an inversion of technique. Incremental techniques of argument by analogy are supplanted by broad appeal to policy. All of this seemingly contradicting the court's own prescriptions as to legitimate judicial method. Similarly, in Lewis, the driving force behind the decision was not a careful working out of precedent in false imprisonment, but rather the assertion of a meta principle of compensation. Whereas the court in various tort contexts has repeatedly cautioned against reliance on broad meta principles, insisting that courts must reason incrementally from established authorities. So in conclusion, let me say the following. Where a court simultaneously cuts down rights protections, does not reason transparently by reference to the law's pre-existing commitments, and deviates from its own view of legitimate judicial method, the court, as a public institution, should expect to face scrutiny of its decision-making. Thank you. So I'll now pass over to Tim.
Many thanks, Jason. First, I'd like to acknowledge the traditional owners of the country upon which we are all located. In my case, I pay respects to the Wurundjeri people of the Kulin Nation, to the ancestors that continue to inhabit the land, to the elders that provide leadership and guidance, and to the younger generations that continue to fight for equity and justice for all of us. I pay my respects as a Yuin person with connections to Wiradjuri country, whose traditional lands are on the south coast of what we now call New South Wales. So civil liberties have traditionally been characterised as negative rights, to be free of particular action by the state. This often jars with the conception of rights for Indigenous peoples in at least two respects. In many ways, Indigenous peoples, through their identity as members of communities and societies, acknowledge that the rights that they hold are held communally and cannot be divorced from their collective identity as Indigenous peoples, as well as in the exercise of those rights being held as individuals. The second respect is often that Indigenous peoples will characterise the nature of their rights as imposing positive obligations on both them and on the state to recognise them, particularly stemming from the right to self-determination. However, as Jason has noted, at a fundamental level, civil liberties may be characterised at a higher level of generality, namely that they refer to the protection of human rights and interests, particularly against the state. For the purposes of my presentation, I want to focus on, generally put, the right to property. Put very simply, in the liberal sense, the right to property involves freedom to own and use land and be free of interference in the use of that land and occupation of that land from others and the state. Now, this isn't wholly incompatible with Indigenous notions of land. Concepts such as ownership and freedom to use resources and to occupy the land without the interference of others plays a part in Indigenous conceptions of land rights. But there are also key differences in the nature of Indigenous relationship with land and waters, built on the concepts of reciprocity and mutuality that fundamentally inform the nature of that relationship. So I want to focus on how the High Court in particular has viewed the Indigenous relationship with land and waters in the recent cases of Northern Territory and Griffiths and Love and Commonwealth, Toms and Commonwealth, which I'll refer to as Love and Toms. I want to explore how these decisions might interact with how we conceive of the civil liberties of Indigenous peoples. Northern Territory and Griffiths concerned the amount of compensation payable under the Native Title Act to the Ngali Wuru and Nungali peoples for the loss, diminution, impairment, or other effects of certain acts on their native title rights and interests over land in the area of the township of Timber Creek. One of the issues before the High Court, following decisions by the trial judge and full court of the Federal Court, was how the award of compensation should account for cultural loss in the sense of loss of traditional attachment to the land or connection to country. As described in the decision in Ward, relying on the Gove land rights case, the nature of the relationship between Indigenous peoples and the land was characterised as one, in a sense, of being a religious relationship, that there is an unquestioned scheme of things in which the spirit ancestors, the people of the clan, particular land, and everything that exists on and in it are organic parts of one indissoluble whole. In Griffiths, the trial judge was required to determine the essentially spiritual relationship of the claimants with country and translate the spiritual hurt from the compensable acts into compensation. The High Court recorded the depth of feeling and hurt based on the compensable acts and the effect on cultural loss. That loss of connection to country is incremental and cumulative and has to be understood in terms of the pervasiveness of the dreamings and the significant sites on country. The nature of the one indissoluble whole of Indigenous connection to country had an impact on the assessment of non-economic consequences of the compensable acts, with the court rejecting that a lot-by-lot approach could be adopted to calculating such loss. In the words of the High Court, it was as though the earlier acts, not compensable, punched holes in what could be likened to a single large painting, a single and coherent pattern of belief in relation to a far wider area of land, and subsequent compensable acts punched further holes in separate parts of the one painting. I recently appeared in an Aboriginal land claim hearing under the Aboriginal Land Rights Northern Territory Act, where many of the claimants explained their connection to country with beautiful simplicity in the language of, I know that country, I know the names of that country, I can name that country. In its simplicity, it suggests the depth and breadth of feeling for and relationship to land and waters. Adjunct Associate Professor Mary Graham and Associate Professor Morgan Brigg, both at the University of Queensland, with Professor Graham being a Kombumerri person and affiliated with the Waka Waka peoples, have written that, start quote, political order for Aboriginal people arises because Aboriginal people are relationally embedded in a sentient landscape or country with each other and other than human beings. This environment allows for individual autonomy, expression, and idiosyncrasy, while also invoking relational reflection in all members of society. How does each person weigh or measure their behaviour and their relations with kin, with those outside the clan group, with country, and with totemic and ancestor figures? Reflection is necessary to achieve self-regulation through attention to what is appropriate and, crucially, proportional in the circumstances and relations in which one is embedded. Behaving proportionally does not involve blindly following rules or those who have gone before. Such didactic guidance is generally not available and would cut across individual autonomy, although protocol is crucial to provide stability. The reflective task is to understand and adopt measured relationships that secure human socio-political ordering through a relational and custodial ethic. Land does not actually need any human or particular life form to care for it, but looking after land as country and looking after each other secures the possibility for sustained human life, end quote. Such a conception of political order engages, but also redefines liberal concepts of individual autonomy and collective sovereignty, and bases such concepts deeply for Indigenous peoples. That means political order is symbiotic with our relationship to land and waters. The question then becomes, what responsibilities are on the settler state to understand and recognise this ancient political order, that has inhabited and is a fundamental part of the land of Australia and continues through our relationship as Indigenous peoples with country in the exercise of the settler state's own sovereign power vis-a-vis Indigenous peoples. Which brings me to Love and Toms. The unique relationship of Indigenous peoples with the land and waters of Australia formed a key basis for the majority judgments in Love and Toms. A majority of the High Court, comprised of Justices Bell, Nettle, Gordon and Edelman, found that Aboriginal Australians, understood according to the tripartite test in Mabo No. 2, are not within the reach of the aliens' power conferred by section 51(19) of the Constitution. On the question of the relationship between Indigenous peoples and the land and waters of Australia, Justice Bell noted that Mabo No. 2 had recognised that at the time of European settlement, there existed antecedent rights and interests in the land and waters of Australia possessed by Indigenous persons sourced in traditional law and custom. This connection with country is essentially spiritual, and therefore there was an incongruity between the recognition by the common law of Australia of the unique connection between Indigenous peoples and their traditional lands, and a finding that Indigenous peoples could be described as aliens. For Justice Nettle, more fundamental than the common law's recognition of native title rights and interests arising under traditional law and custom was the recognition of the Aboriginal societies from which those laws and customs organically emerged. Accordingly, to treat a member of such a society as an alien would be to acknowledge the Crown as having the power to tear the organic whole of the society asunder, which is the antithesis of the common law's recognition of that society's laws and customs. Justice Gordon wrote of the deeper truth of Mabo No. 2, being that Indigenous peoples were the first peoples of the country, and that the connection between them and the land and waters that now make up the territory of Australia was not severed or extinguished by European settlement. By reference to the Gove Land Rights case quoted in Ward, Her Honour highlighted the nature of the spiritual connection to land and that connection persists. The constitutional term aliens conveys otherness and being an outsider, which could not apply to the original inhabitants of the country. As Her Honour stated, failure to recognise that Aboriginal Australians retain their connection with land and waters would distort the concept of alienage by ignoring the content, nature and depth of a connection with land and waters. This relationship is a unique one for Indigenous Australians. Justice Gordon noted that Indigenous connection with land is where the land owns the people and the people are responsible for the land, a two-way connection rather than the one-way connection common lawyers identify as rights with respect to or over an article of property. Importantly, Her Honour stated that justice dispossession of traditional land and waters does not strip Indigenous Australians of their rights and interests. It does not strip them of their connection with land and waters. Justice Edelman wrote that the identity of Aboriginal people, whether citizens or non-citizens, is shaped by a fundamental spiritual and cultural sense of belonging to Australia. Accordingly, Aboriginal people were permanent members of the political community of Australia and belonged to Australia, therefore meaning they could not be aliens. His Honour referred to Aboriginal people as inseparably tied to the land of Australia and thus to its political community, with metaphysical bonds that are far stronger than those forged by the happenstance of birth on Australian land or the nationality of parentage. The consequence of the relationship between Indigenous Australians and the land of waters of Australia is that Indigenous Australians are not aliens under the Constitution. Therefore, as the power to remove a non-citizen from Australia is dependent on the alien's power, Indigenous Australians are beyond its reach and cannot be so removed. it is an open question as to whether, for similar reasons, it is unlawful to detain an Indigenous Australian as a non-citizen pursuant to the Migration Act. In some ways, Love and Toms could be characterised as a case acknowledging a sphere of protection or constitutional immunity for Indigenous peoples from removal from their traditional lands, at least in a pan-Australian sense. To that extent, it aligns with and is indicative of the unique status of Indigenous peoples and the effect of that unique status on their civil liberties, particularly regarding detention in and removal from Australia. However, there is a more fundamental acknowledgement arising from Griffiths and Love and Toms regarding the unique position of Aboriginal and Torres Strait Islander peoples that is beyond liberal concepts of individual rights and liberties, and involves engaging in an attempt by the High Court to more deeply understand Indigenous concepts of identity, country, and community. In other words, as Professors Graham and Brigg discuss, Indigenous political order. The decisions not only recognise our connection to country, but our essential identity as a community of peoples or as members of societies. Put another way, the very fact of Aboriginal identity is an indissoluble whole. It speaks to the deeply inherent connection that we have to land and waters that cannot be erased by law and cannot be erased by the nation state. The question then is what impact this has for the relationship between the Indigenous peoples of Australia and the state. Fundamental to the concept of the protection of civil liberties. It is the foundation of Indigenous connection to land and waters that must inform that relationship and further inform the responsibilities of the state vis-a-vis its Indigenous peoples, whether that relates to compensation for the loss or impairment of native title rights and interests, or the capacity to detain and remove Indigenous non-citizens, or other legal issues that might arise for the High Court. A final comment, we as a community, and specifically us as a legal community, must deeply interrogate any political or legal desire to suspend, minimise or erase the recognition of Indigenous rights and interest, and the impact of those desires on the long-term relationship between the state and Indigenous peoples. The relationship has been fraught for a long time. Nonetheless, I am a believer in the words of Martin Luther King Jr., that the arc of the moral universe is long, but it bends toward justice. But it does not bend on its own. Human action is required for it to do so. It is hoped, as the decisions in Griffiths and Love and Toms indicate, that the High Court continues to recognise and, to the extent it can under law, protect the unique status of Indigenous peoples. I'll now pass on to Laureate Professor Emeritus Cheryl Saunders. Thank you.
Well, thank you for joining us tonight, everybody. My role is to put these cases in broad context of the Australian legal and constitutional system. Alan Missen was a great parliamentarian. He understood the role of Parliament in protecting civil liberties and fought to ensure that the Parliament of which he was a member did so. I like to think he would also have approved of the theme for tonight's event held in his name, the complementary but equally important role of that other great institution, the High Court of Australia, in the protection of civil liberties in this country. The High Court has final responsibility for the evolution of the common law of Australia and for the interpretation and application of the Australian Constitution. Both have a bearing on civil liberties, understood to include the fundamental rights and freedoms of the kind that Jason described and have been examined by the earlier panelists. The role of the High Court in shaping the common law in ways that respect civil liberties is shared by courts throughout the common law world. Of course, much of the common law has now been modified by statute, but there's plenty of life in the common law yet, as cases like Smethurst and Roy tell us. And in any event, the common law also includes the principles of statutory interpretation, most of which are developed by the courts themselves. That still influential figure, Albert Van Dicey, long ago relied on the role of courts in interpreting legislation that Parliament had made as the key to reconciling his versions of parliamentary sovereignty and the rule of law in ways that protected civil liberties. Of course, also in Australia as elsewhere, both common law and statute now are overlaid by written entrenched constitutions enforced through courts. Such a constitution is critical to any understanding of the role of a court in protecting civil liberties. In Australia's case, the Constitution has some highly distinctive features that make it relevant to the topic tonight. Let me mention three, linking them to some of the cases that the others have discussed. First, and most obviously, the Australian Constitution provides almost no explicit protection for civil liberties. One effect of this is to leave many civil liberties to protection through the common law and statute, making even more important the role of the court in dealing with those sources of law. Secondly, however, the absence of rights does not make the Constitution irrelevant for present purposes. The Australian Constitution instead protects the institutions of government, consistently with the principles of both federalism and separation of powers, Australian style. The effectiveness and integrity of these institutions is critical because they, in turn, also have responsibilities for civil liberties. But in addition, some ancillary constitutional protection for civil liberties has emerged as a byproduct of the provisions protecting institutions. A familiar example is the constitutional freedom of political communication, which emerged as a corollary of the system of responsible government for which the Constitution provides. Other examples of this phenomenon follow from the entrenchment of independent courts exercising judicial power, and let me give you three. First, it's hard to overestimate the importance of the section entrenching the jurisdiction of the High Court to issue remedies against officers of the Commonwealth, including the remedy of the injunction, about which there is still much to be said following an inconclusive treatment of the topic in Smethurst. Secondly, the effectiveness of independent courts exercising judicial power inevitably requires protection of some aspects of due process. And thirdly, the separation of judicial power also means, as Michelle explained, that only the courts can deprive someone of liberty as a punitive measure. I can't repeat at this point Michelle's very rich analysis of how that principle is played out in the immigration context. Let me just say that how that principle applies to immigration detention in Australia, where detention is claimed not to be punitive, but persons are effectively deprived of their liberty by legislation and executive action, potentially forever, is an issue at the heart of the cases that Michelle discussed. And our apparent inability to resolve that problem is a continuing indictment of all our institutions. A third distinctive feature of the Australian Constitution, with a bearing on tonight's theme, is its evolutionary character. It's necessarily becoming evolutionary because Australia did not become independent for more than 30 years after the Constitution came into effect. However visionary the framers of the Australian Constitution are claimed to be, the Constitution inevitably bears hallmarks of its colonial origins. It's been the task of the High Court to adapt the Constitution to the realities of independent Australia. This occurred, for example, as Australia began to conduct international relations for itself, as the United Kingdom became a foreign instead of an imperial power, and as the monarchy morphed from the Crown of the United Kingdom of Great Britain and Ireland, to which the Constitution Act refers, to becoming the Crown of Australia to which it doesn't. One other hallmark of the lack of independence at the time the Constitution was framed is the absence of any constitutional concept of belonging. Instead, we have a constitutional concept of not belonging in the shape of the aliens power of the Commonwealth Parliament. What that power means and its relationship to the statutory status of citizenship are ultimately for the High Court to determine. Determination is complicated by the settler nature of most of the Australian community and by Australia's relationships with its nearest neighbours, Papua New Guinea and New Zealand, which, although in different ways, have facilitated the mixture of populations over time. There have been many chapters of that story already, and it's not over yet. But whatever the meaning of alien, in those broader contexts, it seems entirely counterintuitive to suggest that it could apply to the Aboriginal and Torres Strait Islander peoples of Australia, whether they are formally citizens or not. In Love and the Commonwealth, a majority of the High Court mercifully agreed, although in more sophisticated terms, in the way that Tim described. As Tim's presentation also reminds us, there's one other respect in which the Australian context also might be described as evolutionary, which has nothing to do with independence. And that concerns the evolving legal and political relationship between the Indigenous peoples of Australia and the Australian state. That journey is also very far from finished, but we've come a long way from the Constitution of 1901 that provided Aboriginal natives shall not be counted. Of course, part of that evolution is achieved through formal amendment of the Constitution itself, and rightly so. But changes in that relationship must also be accompanied by conceptual shifts in law and legal thinking for which the High Court ultimately is responsible. Development of the deep understanding to which Tim also referred. One other dimension of the Constitution that might be thought to be relevant tonight is the implications of the separation of judicial power for the scope of the authority of the High Court. But none of the cases and the issues canvassed this evening brings us even close to the constitutional borders of judicial power. All lie within the heartland of judicial power under a common law constitution, and all can be dealt with through the familiar techniques of Australian legalism, which at its best draws on the interpretive and analytical tools of the common law to draft answers to problems that are legally sound, consistent with principle, and conducive to the coherence of the law. The difficulty of the task that the High Court faces in protecting civil liberties through law in Australia should not be understated. The absence of codified rights, which makes the other techniques I've described so important, deprives the court of explicit standards to guide its decisions. Worse, it deprives governments and parliaments of explicit standards as well, placing an additional premium on the clarity of the court's reasons for educative purposes. In addition, by definition, almost all civil liberties cases involve governments in some capacity. Many come before the court in highly sensitive contexts. Several of those discussed this evening fall into that category. But that is not new territory for the court, as the 70th anniversary of the Communist Party case reminds us. The court is equipped to withstand such pressures by the protection provided through the separation of judicial power. Nevertheless, it's a source of tension in a country where politics is played hard and often without reference to principle, or at least so it seems to me. It behoves us all to be vigilant for that reason. One final closing remark, and then we'll move to question time. We've spoken all evening about the role of the High Court in protecting civil liberties, and that's fair enough, because the High Court has the final word in the cases that reach it. But in reality in Australia, all courts play a role in protecting civil liberties, and intermediate appellate courts in both federal and state court systems have particular responsibilities in this regard. Some years ago, the High Court published reasons that discouraged intermediate appellate courts from taking significant initiative, my phrasing, in matters that came before them. In my view, this was a mistake in all areas of law, including the protection of civil liberties. Many cases end at the intermediate appellate stage, making it important for these courts also to play a substantive role in adapting Australian law to new challenges. Equally significantly, however, the High Court itself can benefit from deliberations of earlier courts, as the experience of other jurisdictions shows. In the world of judicial protection of civil liberties, with all its tensions and complexities, there also may be much to be said for sharing the load. And now let me turn you over to Adrienne Stone to chair the question and answer session.
Well, thanks to all of our panelists. I hope that they can now turn on their cameras and be part of the discussion. A reminder to everyone that you can put your questions in the Q&A function, and I will do my best to summarise them and pull them together. Now, we have a raft of questions already there, and there are a couple of questions that I might start by putting to Michelle Foster initially, but of course any other member of the panel who would like to comment should do so. There are questions, Michelle, for you about the Al-Kateb case. And one question is why AGL hasn't provoked the immense media scrutiny and commentary as the 2004 decision of the High Court in Al-Kateb. And I might at the same point put to you the other points, which is that whether you think there is a case to argue that unlimited detention should itself, by virtue of that fact, be seen as punitive. And then a last question is, why do you think the High Court makes little reference to the fact that detention for a criminal offence cannot be indefinite, yet indefinite detention seems to be contemplated in this area? Perhaps I could take that little set of questions over to you.
Sure. Well, thank you so much. And thanks very much to our audience members for those great questions. So I'll start with the first one. Why didn't AGL 20 get much publicity? I think it's a really interesting question. I mean, I guess just a really straightforward response would be to say the timing. It was June this year, and what are we all obsessed with this year? It's not the rights of asylum seekers. It's, you know, our issues around COVID. But I think more deeply, I mean, I would say that over the last 15 years or so, we have seen really just a reduction in debate about all of our policies, not just immigration detention, but I think all of the relevant policies. So we think about offshore processing. The UN Special Rapporteur on Torture has found that we are in violation of our obligations under the Convention Against Torture, essentially saying that subjecting people to the conditions there amounts to torture. You know, it's a fairly shocking finding, but really no discussion. We also have very draconian policies onshore, not just detention, but subjecting people to temporary protection visas, so they need to constantly reapply. We won't go through the whole raft of policies at the moment. But there's a lot of concern amongst a certain community about these, about those who are concerned about asylum seekers. And yet I think the questioner is right in observing that we just don't see that debate. Now, I'm not an expert on public opinion, but I do think a couple of points are relevant. I do think that there's been a dismissal by the government of international law, sort of a move away from the relevance of international law, from multilateralism, a dismissal of whether or not that's even relevant. But I also think that to some degree, these policies have just become normalised. I think that idea that these are, you know, on-water matters, that these are not matters for the public, you know, these are matters solely within the discretion of the executive, and I won't name which relevant ministers over time have made those statements. But I think eventually they have seeped into our consciousness as a nation, and that they just have become normalised. Of course, I think that we do need to debate them. And I saw that there was a question about whether we should have a Bill of Rights, and that's something that we, you know, maybe can talk about later. But I do think that we need to have a discussion about these issues because, as Cheryl said, we have to reckon with them. I mean, I think immigration detention is one of the great moral challenges of our time, and we just have to keep talking about it. The other question was about, I think, whether the fact that the detention can just be indefinite makes it punitive. I mean, it depends on how how you approach this, because of course, if you ask the individual who's subjected to that, of course it's punitive. It's punitive to be in there for more than what might be regarded as absolutely minimal. So from international law's perspective, about 3 months is what most international bodies would say is reasonable. So it's not unlawful ever to detain, it's unlawful to arbitrarily detain a person. So if you can be detained for the purposes of sort of basic checks, and after that, it certainly does become punitive from the individual's perspective. But of course, that's not the way the court has assessed this. I think, in Al-Kateb, as many of you will know, the question was whether the purpose was punitive, not the effect. So again, it depends on how you assess whether it's punitive. If it's the object of the act, well, the court has said objectively the purpose is what we've already talked about: segregation from the community, availability for deportation. It's not a punitive purpose, but of course the effect on the person is punitive. I guess what I was trying to say was that between Al-Kateb and AGL 20, I felt the court was moving to a more structured analysis whereby one looks at the purpose, and it needs to be for a very limited, legitimate purpose, and then moving to whether the detention is reasonably capable of being seen as relevant to that purpose. And of course, if it's indefinite, it's going to be much harder to argue that it's reasonably capable of being seen, etc. And then it's only if it meets that test that it's non-punitive. Whereas, of course, in Al-Kateb, the court had just gone straight to the question of whether it's punitive or not. So I suppose, the short answer is to say, most people would say it is punitive, but the High Court has approached this in a different way. So it's still, it's an ongoing discussion, which again, as Cheryl said, we need to have as a community, because I think what we're seeing is the response to this problem is not going to come from the court or a solution, if you like, or a remedy. For quite a few years there, many advocates, many of those concerned with the plight of asylum seekers in Australia were saying the High Court, there's life in Chapter 3 yet, there's life in Lim yet. We just have to wait for the right case to get to the court. But I think we're now seeing post AGL 20 that is probably not the case. So we need to look at other solutions, whether that's a Bill of Rights, parliamentary change. We have to look at those other solutions. Just very briefly, the last point about the comparison with the criminal law. I think there are some examples where one can be given a life sentence. I'm not sure that it's right to say that one can never have effectively an indefinite sentence. But I think it's a good point from an advocacy perspective. And I think when I teach indefinite detention, when I talk about this in class, people are often really shocked when they realise that a person can actually be in detention for the remainder of their natural life, not on the basis of a conviction. They might be deemed unlawful. That doesn't mean they've done anything that's unlawful. They haven't necessarily violated the law even in arriving in Australia, and yet can be subjected to this regime of detention. So I think that, from an advocacy perspective, that's just a really important point to make, because I think there's a lot of misunderstanding about why people are in immigration detention and what the basis for it is. That's a very quick response to all of those very good questions.
Adrian, can I say something quickly also in response to that?
Absolutely. Go ahead, Cheryl.
I of course agree with everything that Michelle just said, but I think one of the other reasons, it's just so that AGL 20 hasn't attracted so much attention, is that it's so hard to understand this stuff. It's very hard to understand the idea that civil liberties might be protected indirectly through protection for institutions in the Constitution. That's a complicated enough story. But when Lim was decided and Al-Kateb was decided, the doctrine was still straightforward enough to be comprehensible. The layer upon layer upon layer of what is or is not problematic detention has just made it impenetrable. And I'm grateful to Michelle for explaining it so clearly as she did tonight. But I do think that that's a problem. And it's a problem that the court itself also, I think, needs to address in trying to ensure that the principles on which its decisions are based are as accessible to the community and to institutions as possible.
Thank you. Do any other panelists want to come in on that? If not, I'd just like to put a question to Jason Varuhas. Jason, our question has entered you to consider the analysis of the court in Bidsaris and NTA and how that compares to the cases that you considered.
Thanks very much. And I'll just add, just following on from that, the points that Michelle and Cheryl made, that in terms of a case like Roy or Lewis, similarly, they're cases that can sometimes fall between the cracks, even though they raise fundamental points of principle. And in that case, because they implicate considerations of both public and private law. Private lawyers might think public lawyers will cover this, and public lawyers think private lawyers will cover these cases. Smethurst got a bit more coverage, and that's really because of the constitutional injunction, and the constitutional lawyers are onto that. But that's another case that implicates constitutional law, tort, and equity, and is therefore quite difficult to navigate. Now, turning to the question about Binsaris. So that's an interesting question. So Binsaris was a case that I believe was also decided last year, and it was also a torts case decided by the High Court of Australia. Now, in that case, what happened was, and this is, forgive me if there are any slight inaccuracies in this because this is all from memory, but what happened was that in Northern Territory Youth Justice or Detention Facility, officers used a type of tear gas on youth detainees. Now, using tear gas on people is a battery because it's an interference with their physical integrity. Now, the question was, and what the case revolved around, was whether there was statutory authority for the officers to use this particular type of weapon, the gas. And the court found, from memory unanimously, that there wasn't statutory authority to use that gas, and so there was a battery. Now, what's interesting about that case, and it's my abiding memory of the case, is although it's a case which concerns the right to physical integrity, right fundamental in the common law tradition, the judgments largely don't start from that. The judgments start from an interpretation of the statute and approach the interpretation of the statute simply on ordinary principles. So from memory, I believe it's just only Justice Gageler who explicitly enunciates the principle of legality, which is what one would expect, the principle one would expect to find enunciated here, that you need express words or necessary implication to authorize an interference with a legal right, a fundamental right protected by the common law. So in one sense, the case is distinguishable from those that I've been discussing because it reaches a conclusion which is favorable to the protection of the common law right. But in another sense, it's consistent with the cases I've been discussing in terms of the reasoning, because the starting point articulated is not this normative starting point one would expect to be articulated in the theory of the law, which is if you've got a claim in battery, the starting point should be the right to physical integrity. And then the question is there statutory authority to interfere with that right? And because that's a defense, lawful justification, it should be construed, the statute should be construed narrowly and on the basis of the principle of legality. You need clear words to authorize the interference. But you don't really see that mode of reasoning except from Justice Gageler. So it goes to it's consistent with the points I was making about the court perhaps not starting from the normative starting points one would expect, given the normative order of the law. And I'll just add to that that's consistent with Roy, because in Roy, one would expect to see an analysis in terms of the principle of legality, right? Police enter land. There's a statutory scheme governing powers to deal with domestic violence, right? And therefore, the principle of legality would suggest you look at the statutory scheme. Are there clear words in there to authorize this entry? The answer would be no. But that also would color the analysis of the implied license if that was applied, because then you'd say there's not much point in the principle of legality. If you look for express words in the statute to authorize the interference, don't find them. But then the court just enables the interference anyway. It takes a lot of the normative force out of the principle of legality. And it also undermines the principle that if there's going to be an interference with a basic right, one would ordinarily expect that to be on the basis of express terms in a statute, because one would ordinarily expect there to be a democratic mandate for so serious a consequence as interfering with rights. And that wasn't the case in Roy, yet a license was recognized at common law.
Jason, there's another question for you, and it's long, so I invite everyone to look at the whole question in the Q&A if they want to, but let me just give you a simplified version. The question is, what are your thoughts on the High Court's approach in Lewis in separating the liability issue of false imprisonment from the damages issue? And the questioner, it's Jason Varuhas from Deakin Law School, particularly invites you to consider the question of nominal damages in this context.
Okay, so I'm looking at the question. I'll start with the reference to Plenty and Dillon, I think. So one of the things that Jason says is that Justice Edelman invokes Plenty and Dillon and the lower court decision that followed from the High Court's decision in that case. So Plenty of Dillon's and Dillon's important in this context because it was long considered to be a case which upheld the principle that if there's an interference with a right protected by a trespassory tort, you can get damages for the interference as of cause. And it was interpreted in that way, not just by me, but for example, by the New South Wales Court of Appeal, which has awarded significant damages for the interference of the right in itself. But in Lewis, it was reinterpreted and as not supporting that proposition. And one basis on which it was reinterpreted is that when the High Court referred that matter back to a lower court, the lower court gave damages for what might be called factual losses, such as distress, not for the interference with the right in itself. Now, my response to that would be that what the lower court did there is not really relevant or legally salient because they may have deviated from what the High Court said. And the High Court statements in Plenty are pretty definitive. For example, Mason, Brennan, and Tui say, this is an action in trespass, not in case, and the plaintiff is entitled to some damages and vindication of his right to exclude defendants from his farm. Gordon and McHugh said, once a plaintiff obtains a verdict in an action of trespass, he or she is entitled to an award of damages. This is pretty definitive that if there's an interference with one of those rights, damages follow. There's no hint of causal analysis there as was adopted in Lewis. Now, one of the other things, and I'll be quick because I know there are some questions there for Tim. And one of the questions Jason asks is, well, if these aren't damages for sort of factual losses, so the damages I suggest is that if there's an interference with basic rights, you should get damages for that interference. And Jason asks, well, they're not compensatory for factual losses and they don't seem to be nominal damages. So what are they? Now, I would say, and I've argued this in the Sydney Law Review last year, that these are a form of what I call normative damages, that the law constructs a form of damage that exists only on the plane of the law to give effect to the normative concerns of this area of the law. So where there's an interference with a basic right, the law constructs a loss so that substantial damages follow the interference with a basic right, and that serves to afford strong protection to those basic rights. And that sort of constructed loss is not unique to trespassory torts. It also exists in the law of contract, for example, where you have the constructed loss of expectation loss, which doesn't correspond to any real world effect. There's no expectation loss in the world, but nonetheless, the law recognizes that loss to give effect to the promises, because if you could breach promises without any damages being awarded, people wouldn't take their promises that seriously. So that's my answer in a nutshell, but I'm aware time is pressing, so I'll stop there.
Thanks, Jason. Let me quickly put two questions to Tim, and then I'd like to put a question to the whole panel. One question relates to the question of Mr. Tom's detention between 2018 and 2020. Whether you could comment on its legality and the use of habeas as a remedy in this context. And the other question comes from Olivia Barr, and she invites you to think about a bigger canvas. These cases, she says, indicate a shift in how the High Court views Aboriginal relationships to country. This is a good start. But what comes next? Can the High Court go further? And if they do, what might be?
Yeah, two great questions. I won't presume to be an expert on the on Tom's number two, but it's right to say that it will return to the High Court. And there was a directions hearing, I think, on Monday regarding the return to consider the lawfulness of Mr. Tom's detention. And there are a number of cases in the federal court, because of course it's a question of fact over whether a person, a non-citizen, is an Aboriginal Australian, and a number of cases have been making their way through the federal court on that issue. And a number of them involve habeas applications as well, because certain persons are still in immigration detention. So it's definitely going to be an interesting part two of Love and Tom's that the High Court will consider. And in particular, I think as Cresta notes, that's going to engage consideration of the operation of the tripartite test. I've done another number of presentations on Love and Toms, and I always say there are so many layers to the decision that could be discussed, and I've previously discussed the impact of the incorporation of the tripartite test as essentially a constitutional concept by reason of the decision in Love and Toms. And so it's going to be very interesting as to whether, as I suspect, the High Court will be asked to say more about the operation of the tripartite test, and in particular what is often seen as the third limb of the, or described as the third limb of the tripartite test regarding community recognition, which actually involves Aboriginal people themselves recognising and having the right to recognise their own membership as a reflection of self-determination, and how that is incorporated into the definition of an Aboriginal person itself, and the consequences that that has as to how, well, as to whether they fall within or without the alien's power. So that it's going to be an extremely interesting development in constitutional law. I don't know where it will go, but I'll watch with great interest. In terms of the second issue, in terms of what more can be done, I think the really interesting issue that Love and Toms highlights is a reflection on the relationship between the state and Indigenous peoples, and how that relationship evolves from hopefully a negative to a positive relationship. And so what Love and Toms says about the nature of that relationship and the importance of the relationship between Indigenous peoples and the land and waters of Australia, and what that says about the permanency of the existence of the very relationship between the state and Indigenous peoples, because of the permanency of the relationship that we have with the land and waters of Australia. And so how do we settle, in a way, the disagreements, or in the language of Griffiths, hurt feelings that have occurred by reason of the history of that relationship? And that calls into question a reframing of political order, particularly through how we talk about nation building, constitutional amendment and treaties. And so I think that the High Court has, in a way, almost issued a challenge, because it has to deal with any controversy that comes before it in the moment. But in many ways, the majority judgments and even the minority judgments, in many ways, issue a challenge to how we reframe and constitute the relationship between the state and Indigenous peoples. And that will involve the High Court, but in many ways it won't. So that's the real issue. And I think that speaks to Cheryl's challenge at the very end of her presentation, that this is not only about a reliance on the High Court's institutional position regarding civil liberties, but it involves a challenge on all of us.
I had hoped we'd have time for a further question, as we're really starting to get to some of the big and difficult issues. But in light of the time, I think I had better wrap up. We've had the benefit of such interesting and rich set of comments, and invite Jason Varuhas to close the session for us. Thank you.
Very much, Adrienne. So I'd like to conclude the event with some thank yous. So thank you once again to our excellent speakers for their insightful and thought-provoking presentations. Thank you, Professors Foster and Saunders and Tim. Let me also thank Professor Stone for chairing the question and answer session. And thank you to all of those who attended this evening. We're grateful for your support of this event and Melbourne Law School. And thank you to all who asked such excellent questions. And lastly, let me once again express our thanks to the Alan Missen Foundation. We're most grateful to the Foundation for its support of this event, and we hope the event carried forward the Foundation's mission of promoting public education concerning civil liberties and human rights. So, good evening, everyone.